go to the restream, see what it does. Well, we're on something.
Well, it says live.
All right, let's turn it on. All right, we should be going. So this is Keith, and this is Stuart.
Is it 1:30?
No, but we're getting started early to get it going. This is the first time that we're going to do a simulcast on YouTube and Facebook. So we're getting it going. Looks like we're live on Facebook, and we're just about live on YouTube. But we thought we'd get it started just a little bit early to get it up and running, give people a chance to tune in, and give us a chance to make sure everything's working. So this is going to be our weekly live segment. This is Keith Davidson right here, Stuart Albertson over there. And our plan is to be able to come to you on a weekly basis, and we'll be talking about things in the trust and will litigation world that we deal with, and it's things that you might find interesting as well. We certainly hope you do. Primarily, we're going to probably be going over a lot of our most recent appellate cases that come out by the California Appellate Court. So that's kind of the current events in our world. And we can kind of take some lessons from that as we go. And then as well, there's some other topical issues that we want to cover with you that we'll be covering today, but also in future episodes too. And then it'll just give us an opportunity to also answer your questions. So if you have any questions, you can submit those on Facebook, or you can submit those on YouTube. So are we up on YouTube now?
Not quite.
You might want to switch over to the YouTube account on the Windows and kind of see what it looks like. All right, there we go. So I think we're good to go. So go ahead and feel free to ask questions. If you're on YouTube, you can ask your questions there. If you're on Facebook, you can ask your questions there. And our lovely and helpful assistant, Kayla, will be watching for your questions and will be letting us know when they pop up. And you have the Facebook account, Kayla, so we're good to go there too.
We're all set.
Awesome. All right, Stuart, so what did you want to start with today?
So I came across a new device in the Discovery Act that's going to be very helpful to us. They're called informal discovery conferences. And you can think of an informal discovery conference a little bit like a mandatory settlement conference. Mandatory settlement conferences, most attorneys are aware of, where courts will order the parties into a settlement conference prior to trial to try to get them to settle the case. Mm-hmm. Well, this is for discovery, these IDCs, they call them, informal discovery conferences. And it's under Code of Civil Procedure 2016-080, and it's effective January 1, 2018. And essentially what you can do with...
I'm sorry, go ahead.
And essentially what you can do with these informal discovery conferences, where this arises is where we have sent discovery to an opposing side, and
right.
They've decided that they don't want to answer that discovery. And we've done the meet and confer requirement that California Discovery Act requires, where we try to reach out to the lawyers and reason with them as to why they should answer this discovery, and they still choose not to. Well, now we can ask the court for an informal discovery conference, or an IDC, so that we can meet with the judge, who can kind of play parent, I guess, between two children, and see if we can present, in our position, we'd be asking the judge to help the other side understand that they owe us the discovery and that we're entitled to it under the Discovery Act. The other side then gets an opportunity to tell the judge why they don't think they have to produce it. The interesting thing about these IDCs, the judge really doesn't even make an order at all. The judge simply tells you, based on their experience of being a judge and being a lawyer, which way they would rule on this case. Well, I think that's pretty important, because if they tell you how they're going to rule and you're going to be bringing a motion to compel in front of them, chances are they're going to rule the same way.
Right.
So I think these are a pretty effective, at least it's an effective idea to get opposing counsel on the other side to respond to discovery. As I don't know if all of our viewers will know, but discovery is it's worse than getting a root canal.
Well, let's talk about, the informal discovery conference. So what you're really talking about is sitting down and talking about the problem with the judge without necessarily having to bring a formal motion. Although maybe you do bring a motion, but you work it out without the motion. For people who haven't been through this process before, what you may not realize if you're a client out there is that when somebody refuses to answer your discovery, your lawyer has to draw up a motion. And that's a lot of work because you have to put down on paper all your legal reasons as to why you think that somebody should respond to your discovery, and they're not going to do that. You also have to do what we call a separate statement where you list out every question you asked or request you made, what the response was to that request, and then why that response isn't appropriate. Well, you can imagine, even if you have a short set of discovery, you ask 30 questions, you have to do that 30 times. And now you have a document, even on a simple motion, your separate statement alone is going to be 30, 40, 50 pages long. And then the motion is another 10, 15 pages. And how much attorney time does it take to draft all that? I mean, you're talking
several days sometimes.
I mean, it could be 10, 20 grand of attorney time. And then what happens? It goes to court, and the other side has to do an opposition, and then we get a chance to do a reply. So that's a further drafting that we have to do as the moving party. It goes to the judge. Well, not even the judge, really. It's usually the research attorney at the court is going to look at it first, and they're going to decide kind of what the issues are for the judge. The judge is going to look at it, and now the judge is sitting there, and keep in mind he's got what, hundreds and hundreds. He or she has hundreds and hundreds of these motions, and they don't really want to deal with them. They don't want to see you in court. They don't want to talk about it, and they have to decide if they're going to allow the motion or not, or what they're going to do with it. So you're talking about, if you didn't have this informal conference idea, you're talking about tens of thousands of dollars of time, both for the attorneys and the courts. And then you usually don't get everything you want on a motion anyway, because the court may see it wrong, or they didn't understand what you were asking for, or who knows what. And then you have to enforce it. So now you get an order, let's say that you do win, and then you have to go out and you have to force the other side to comply with it. And the other side obviously is not happy that you brought the motion, and so maybe they're obstinate even after the court order. You also tend to ask for sanctions, right? You want the other side to pay your attorney's fees for doing all this. And how often do courts award sanctions on discovery motions?
It's rare. In fact, most judges don't want to hear the portion of the motion that has to do with sanctions. Sanctions essentially being, Your Honor, we were forced to file this motion to get discovery that we were entitled to, so you should make the other attorney or their client or both of them pay us money for the time that we had to do to bring this very expensive and time-consuming motion. Most judges won't even address the sanction request at the motion unless you specifically ask for it. And then once you ask for it, they usually say,
They'll deny it.
You're denied.
They'll deny it.
Yeah,
Or they'll give you some, $1,500.
So this is a good start for California law, but I think California could do one better than this, and that simply would be some form of mandatory discovery disclosures like they have in federal court. It doesn't necessarily need to mirror the federal process, but think if you had a requirement in a case as a lawyer that if you file a case or you're answering a case as a litigant, you have certain duties to disclose what you have in your file to the other side without request. It's just something that's due within a certain time frame after the case is at issue. I think that would be the way to do it under California law. And then if you don't produce everything and you're found later to not have produced things, there can be, terminating sanctions. There can be all kinds of different things the courts could do to penalize the party that didn't disclose the information they're required to disclose. But then the court could also, if somebody doesn't disclose something and it's favorable to them down the road, preclude them from using that at the time of trial. So discovery is the bane of existence of most lawyers. I mean, we bring motions to compel in cases, and we know how hard they are to do. Right. So we're going to try these informal discovery conferences and see how they work. Well, we can report back on that, and people can decide if it's worth at least attempting that before you bring a full motion.
But walk me through how these work, because why are these better than a motion? Because do you have to file the motion? Do you not file the motion? Is it, I mean, how are they going to work to help litigants?
Well, and this is where some judges have been very helpful. There's actually one judge in Los Angeles, and she's actually has a standing order, and it's posted right outside of her courtroom. And it says you can't bring a motion to compel in her courtroom until you've done an IDC. So you say, what are you to do? Because as you and I know, once you receive discovery responses, you have 45 days within which to file a motion to compel the other side to produce better responses
Right.
if they haven't done that to begin with. So that 45 days runs fairly quickly according to court calendars, which will stretch out much further than that in most cases. So in her courtroom, once the IDC is set, which her courtroom is very favorable to, they set these quite quickly, there's an automatic stay of that 45 days. And so if you still insist on bringing a motion to compel after the IDC, you'll have 2 weeks to do that after the IDC hearing. So that judge is very friendly.
So you ask it with you said, I believe you start with a declaration or something?
Well,
to the court, or how do you ask for the IDC?
Well, in Los Angeles, in this particular courtroom, you actually just call to get a hearing.
Oh, nice.
Actually, you can go through the automatic hearing system and try to get it that way. But if you can't get it that way, you can call the department, and you can have the department give you a date. The other side can either agree with you, or you can have them come kicking and screaming. And it just gives you an opportunity to sit down with a judge who, again, has a lot of experience generally in these motions to compel, which they've heard hundreds and hundreds of them. And it gives them the ability to give you kind of their 2 cents. And I think it also makes lawyers behave a little bit better than we probably do when we're just dealing with each other. Being a lawyer is a very adversarial system, and we fight hard, and sometimes we don't like the people that we end up fighting against.
Right.
In front of a judge, we're going to behave ourselves. We'll probably even be a little bit more reasonable to find some compromise on, do we really need this discovery? And that's the other question you have to ask yourself. Have we ever filed a motion to compel because we're just angry at the other attorney?
No.
Or have we always filed it because we really need the discovery? And
Right.
that made me pause when I thought about that. I think sometimes our ego gets in the way a little bit, I hate to say, but just because we have a right to get something doesn't mean we should go get it. What if we don't need it? And so we have to ask ourselves, do we really need this? And I think that's where a judge in an IDC who doesn't have a dog in the hunt, who is not passionate because they're just a judge calling balls and strikes, they can look at the 2 lawyers and say, you guys are being knuckleheads. You know that you have to give this information. Why don't you just give it? And you know you can't overreach and get more than what they're willing to give you, so why don't you just accept what they're giving you?
I think that's the key, right? Is trying to find that common ground, because there's a lot of times when somebody, I think you're right, the lawyers get so angry at each other. It's like, I want all of the personal records of the other party, and the other person says you're not entitled to them. And it's just loggerheads, and it's either, all or nothing. And a judge can step in and say, well, why don't you give them this, this, and this, these sets of documents that are relevant to the case, but we won't produce anything else until we see how this plays out.
Right.
There's a compromise to be had there, is the point, and the judge can definitely help with that compromise. But I'm glad to see that the court's gravitating in this direction, because motions to compel are an absolute nightmare. They're expensive, they're time-consuming, and they're the only option you have to try and get something done. And if you don't do a motion to compel, now you've got potential malpractice, because you should have forced the other side to answer these things. And that's the other thing that I think a lot of lawyers have concerns about, is why I'm forced to do these. I have to do them, because otherwise down the line my client might say, well, you should have done this and you didn't. Now a judge can come in and say, well, this is how I view it, and this is what I would suggest you do. It's interesting to me that at the IDC, the conference part, it's not a mandatory decision. So the judge is just going to give a recommendation that's not mandatory, and then the lawyers are going to step out, work it out. And then I guess if they don't work it out, then they go ahead and either file their motion or proceed with their motion if it's already on calendar or filed.
That's correct.
So it's kind of interesting. I think that also is actually a good thing, because it encourages people to be a little bit more open with the discussion, maybe, because they know that the judge isn't going to make a forced decision. It's going to be something that you're going to have to agree to at the end of the day. But obviously, if you're sitting there with your judge, and your judge is saying, well, this is how I view the issue, that's how they're probably going to rule. So it'd be very short-sighted for you to say, I don't care, I'm not going to agree.
And I don't know this to be the case, but I think that we would find this, that let's say you go to an IDC and you're kind of flippant with the judge and you tell the judge, well, I'm gonna file a motion anyway because I think I win on this, even though you've come out against me informally.
Right.
You know that section in the statute that does allow a judge to give you or award monetary sanctions against you?
Yeah.
Maybe there will be some more awards for monetary sanctions
Yeah.
in those cases. So
Yeah, the judge would have a little bit more of an incentive, but it's definitely something that I think we should be taking far more use of. I wish the court would be even more open with other issues like they are with this one, because I think part of the problem as being a practicing lawyer is that even to us, on many occasions, the way the court works is a bit of a mystery. Even though we're in court a lot, different judges do things different ways. I know there's times when the judges do get together and they decide that they're going to start doing a certain thing. You know, whether it's, I think there was a time in San Bernardino, in fact, when the judges decided they are going to start awarding at least some small amount of sanctions on discovery motions and things like that, which, in my opinion, I think there should be at least some amount awarded on discovery motions, because I think it encourages lawyers not to bring them.
Well,
and to work it out.
And I think that what you're getting into there, Keith, is I don't think most people understand that aren't trial attorneys. They don't understand the gamesmanship or the games that are played in the discovery process. And, you know, we'll send out discovery to the other side, which is written questions to the other side that they have 30 days to answer, right?
Yeah.
And what's the first thing we're going to hear 29 days out?
I need more time.
So we give them another 30 days. So we're 60 days out now. And then they call you and ask you for, another 2 weeks usually?
Right.
Okay.
Well, no, they ask for another month, but you give them another 2 weeks.
Okay. So now you're 70, 80, 90 days out from when you sent those questions to be answered.
Right.
And your case is not on hold, but you want to get those written discovery responses prior to depositions, generally, not always, but generally. And then they send you just a bunch of garbage. I mean, it's literal garbage. And it violates the Discovery Act. And can we go and tattle to the court on that person for violating the Discovery Act?
No.
What do we have to do?
Yeah, you have to bring a motion. You got to go through and then after bringing a motion, the judge might say, we'll figure it out at trial. Don't worry about it. Or they might order, yes, you do have to answer it. Whatever it is, it's a lot of work to get just the basic responses that you should be entitled to, which I guess brings us back to your statement of, shouldn't we just follow what the federal rules do?
Mandatory.
It's just a mandatory disclosure.
Right.
And I think in a perfect world, that is what you would do. I think you'd have a lot of lawyers whose heads would be exploding if we started doing that in state court, because it's so vastly different from what we do.
Right.
I mean, can you imagine you start a case, and what is it? Because I haven't done a lot of federal stuff, but you've been in federal court a lot more than I have. But what's the time frame? I mean, what time frame do you have to start like disclosing things? You're talking about in a number of months, I take it, right?
It's very quick, actually. I believe it's been a while since I've looked at the rules, but I believe it's 30 days, and then there's an obligation to do continued discovery. So here in California, let's talk about that for a second. Let's say you finally get them to respond after 3 or 4 meet and confers. I mean, thousands and thousands of dollars of legal fees and arguing with the other lawyer to give you what you rightfully have a right to under the Discovery Act. And then they come into that one document that is going to sink their case, but they come into it a day after they respond to you. They have no obligation to follow up, which just blows my mind. I'm not sure. I mean, we do have supplemental discovery requests we can
Right.
make in California. We can do those twice before trial, and that kind of buttons up those arguments about, well, we received this document after we responded to you. But wouldn't it be nice if there was a continuing obligation for me and the other side to produce all facts, all witnesses, all documents that go to the claims in the case? And now there's no surprises, there's no Perry Mason moments, even though there are no Perry Mason moments in any event.
Right.
At least that's the idea behind discovery. I would like to say that to the people that are making the rules in California about discovery, and if you ever come across this video, we literally have stopped doing most written discovery other than the ones we have an understanding that at least we're going to get a good chance of getting reasonable responses back. And then we just try to clean up all those other questions we would have at deposition. And it's unfortunate because we would be, I think counsel on both sides would be more informed and educated on their cases if we were to get the documents and the positions, the contentions early on in a case before we spend thousands and thousands of dollars and become so emotionally invested in the case that now it doesn't matter if it's a bad case any longer. We're going to go forward on this case.
Or a bad argument when you're trying to get discovery. You're just trying to win because you're so mad at the other side. And if people would properly answer written discovery, it would also shorten depositions because you wouldn't have to probe for all that information. But you can't get it in written discovery because of the gamesmanship and the cost involved in trying to force people to answer. And then when they do answer, it's not appropriate in any event. So there are a lot of problems with how discovery is conducted. And ironically, discovery was meant to make trials more fair and more transparent so everybody has a chance to have equal access to the evidence. And in so many cases, it just doesn't accomplish that goal any longer because of the costs involved and the complexities involved. So hopefully the discovery conference, the informal discovery conference, will start loosening some things up. I mean, what a great opportunity, especially if you're in that particular judge's courtroom where you can just set a date. You don't have to file your motion. You show up, you get an automatic stay on your motion because you don't have to worry about filing it within 45 days. And you have a chance to resolve it without all the cost and heartache that goes into those.
Well, we'll report back on that in a few months and let you know. We have one case right now where we think this may be something we want to try out. But I do know you want to bring something up, and that's an appellate case that you came across this week. It's a fairly new appellate decision, and it's ironic because it's not too often in California. California's got 40 million people, and there's a lot of cases going on. But we know both of the attorneys that argued this case in front of the Court of Appeal. And we also know the fiduciary who was involved. But let me set up the hypothetical, and then maybe you can walk us through this opinion. And by the way, I'll be the first to admit I've always been confused on who carries the burden of proof in an accounting case.
Yeah, it's confusing.
It is confusing, and so you're gonna set that straight for us. But here's the situation. Trustee, a fiduciary, well, interchangeably we can use those terms, files an accounting with the court. Let's say they've been trustee of a trust for 5 years, and maybe they've never accounted for that 5 years, and we represent one of the beneficiaries. And the beneficiary has been abused, they haven't been listened to, the trustee has not made distributions to the beneficiary as required, the trustee appears to have made expenditures for the benefit of themselves when they're not entitled to do that when you're looking through the accounting. It's been filed with the court. The beneficiary gets it. The beneficiary's upset and comes in and sees one of us and says, I want to challenge this accounting. And what happens from there? How does it work? What do we do to challenge the accounting? How do we prove that the trustee breached their fiduciary obligation? What burden is on the trustee to prove, if anything? I mean, what do we do here with this mess?
Yeah, that's always a good question. There's a lot of unanswered questions in accounting cases because usually a beneficiary comes in and they don't know what's going on. They've been kept in the dark. And how do you even, I mean, let's assume that you have a case where you actually were provided with an accounting. Okay, well, that's at least something. You've got something to work with there. As a beneficiary, we can look at the accounting and we can see what assets were reported. That doesn't mean we believe everything that's in the accounting, but at least we have a starting point to start our discovery.
Right.
If you don't have a proper accounting, then it's an even bigger mess because you have to get an accounting, and that can take time because the court will ultimately order the trustee to account. Usually the trustee will be given 30, 60, 90 days to do it. That 60, 90 days passes and the trustee doesn't do it. And you go back to court and the judge says, okay, now I want you to do it in 30 days. And 30 days goes by and they still haven't done it. And the judge goes, okay, now I want it in 2 weeks. And finally, I mean, if you don't get it to me in 2 weeks, you're going to be sanctioned. And finally, here comes the accounting and it's garbage. But again, at least when you have the accounting, that's information. And so that's the starting point for doing your subpoenas. And so every accounting case must have subpoenas because it's the only way to actually get at the source documents. And by subpoenas, I mean go to the banks, go to the financial institutions and get the information.
Let me interrupt you there, Keith. So I just want to make sure that I'm clear on this. And that is, let's say an accounting has been filed with the probate court after that time period you talked about where the trustee simply took forever to file it. But now It's been filed. And so we look at it, it is garbage. We represent the beneficiary. We file an opposition to that accounting. Is that how that works next?
Yes, right. So then you have to file your objections to that accounting, and you have to state what you believe is improper with the accounting.
Okay, so if we see line items where things are written out, $20,000 to cash, $50,000 to cash,
Right.
$10,000 to American Express, that the American Express happens to be the card held by the trustee, and we see those line items, we include that in our objection. Is that right?
That's right.
Okay, so now we file our objection, we're at issue. The trustee created their accounting out of some documents, right? We call those underlying documents. What do we mean by underlying documents?
You're talking about all the financial documents. So the bank accounts, the financial account statements, if they are paying credit cards, the credit card statements. And I was laughing when you said 20,000 to cash and all that, because I remember I had a case fairly early in my career where a trustee was spending just tons of money on credit cards. We got the credit card statements, and it was purchases for Victoria's Secrets, Harry and David, all this stuff. Well, the beneficiary was a 90-year-old man. So I'm not sure.
He might have been an interesting man.
No, he wasn't. At least not on the outward part of his clothing. I don't know what he's wearing underneath. I didn't ever know him to that level, but I don't think he was spending thousands and thousands of dollars on Victoria's Secrets. But that's where, when we talk about the underlying documents, and you're going to go and look at the financial documents that support the accounting, they tell a story. And maybe it's not quite that risque of a story, but they do tell a story. And so you need to get the financial documents. You need the credit card statements, the bank statements, the financial statements. If real estate was sold, you need the escrow documents. What was the final closing statement on escrow? If there's a mortgage, you need to see the mortgage documents.
Any private placement documents?
Oh my gosh, yeah. So, we had a case before too where a trustee invested in private placements, which is something that only high net worth individuals should invest in. Individuals, not high net worth trusts.
And that's because of the speculative nature of those investments?
Yeah, they're not licensed with the SEC. They're not overseen by the government. They're highly speculative, not something that would be reasonable or prudent for a trust investment, and yet there they were. So if you have something like that, you need to see those documents. Those documents must be around somewhere because they're needed to prepare the accounting. You can't prepare an accounting without them. And so where is these documents? You're not going to have them. They won't be filed with the court with the accounting, because the accounting is really just the end product of somebody going through those documents and listing what's in there.
Okay.
But they should be around.
So let's say that you have gotten all those underlying documents, you sent out those subpoenas, and you've got the bank statements, the credit card statements, and the IRA statements, and whatever other financial account statements you need. The court is now ready to set a trial date, sets a trial date, and you and the trustee show up to trial. Who goes first, and what are these burdens of proof, and what do they mean, and how do we walk through those?
And that gets us back to the case, and it's Scott versus McDonald is the case. It just came out in August of this year, and it was the original case was decided in the county of Riverside by Judge Kerriman, which we're very familiar with Kerriman. We were in front of him a lot.
By the way, since this is on the record, I want to point out I think he's a very fine judge.
He
He really is. He is a good judge. I do like Judge
yeah.
Kerriman. He's been very
Yeah.
good to us through the years. He's an honest broker, but he's been very good and fair to us as far as
We have
I'm
no
concerned.
problem kissing up to judges, but in this case, it happens to also be true.
Okay.
So we're both kissing up and truthful, so it works. All right. So this is a really interesting case because you have a trustee. Imagine this: you're a trustee, and we represent a lot of beneficiaries. So we wish that this was the result in most of our cases against trustees. It's not, because the court tends not to clobber trustees as much as we think they should. But unless we're representing trustees, which we do represent trustees from time to time, but only the good ones.
You have to plug your nose when you do that, though, right?
Well, we only represent the good trustees.
Okay, all right.
Yeah, we know that going in. All right. So, but the bad trustees, they should get clobbered, and they're not always clobbered. But in this case, this trustee was clobbered because she went in asking to have her accounting approved and to be awarded fees of $35,000. And the court denied the fees and surcharged her, which means she has to pay out of her own pocket back to the trust over $93,000. Ouch.
So, okay, so you told the beginning and the end of the story. I want to get to the middle here, but I want to punctuate that. And that is, we have the trustee. She filed an accounting.
Yeah.
We had a beneficiary come in and object to it. I'm sure they did their subpoenas like we just talked through and got the underlying financial documents, and a trial date was set. And at that trial, Judge Kerriman, a very fine judge, if we haven't pointed that out yet, he surcharges the trustee, not only denies her the $34,000 in trustee's fee she's requesting, but then surcharges her and tells her, you're going to pay out of your own money $93,000 back to this trust.
Yeah.
And was this a special needs trust?
Yeah, so this was a special needs trust for a beneficiary who was in must have been in some sort of catastrophic accident because she had received a personal injury settlement, but she was, I think, a minor, but also disabled. And so it was put in a special needs trust. Well, the point of these special needs trusts is you're not supposed to use the money for things for daily living because disabled people qualify for governmental benefits that pay for those things. And so the special needs trust is only for extras that would help make the beneficiary more comfortable in their living. The problem is that the trustee really, and she testified to this, she didn't really read the trust.
No, she said she did not read the trust.
Yeah.
Okay.
Yeah, she did not read the trust. Okay, well, there's your first mistake. So if you're a trustee, you want to read your trust. And she just kind of administered it the way she would any special needs trust, is what she said. But the problem is this trust specifically said that distributions could be made to the beneficiary that are reasonably necessary to provide for the care and comfort of the beneficiary above daily living. But it didn't give the trustee the right to just distribute money willy-nilly. And that was really the problem, is that the trustee bought a car for the beneficiary. Well, the beneficiary doesn't drive. The mom drives, and the mom used the car. And so the court's saying, well, that's more of a benefit to the mom than is the beneficiary.
And I want to take a little bit up with you there, and I think you're doing this on purpose. It seemed to me she bought the car for the mom. She didn't buy the car for the beneficiary.
And that's exactly what the testimony showed, is that the trustee specifically said, I'm buying this for the mom because the mom's a full-time student. And she needs a car to get around, but she also is going to drive the beneficiary in it from time to time. Well, that's not what the trust allowed. The trust didn't allow, you weren't allowed to make a distribution from the trust for reasons that benefit the mom. So I'm going to buy a car because the mom's a full-time student. That's not a proper way to look at the trust. I'm going to buy a car because the beneficiary drives and needs a car would be different, a different standard of distribution. So,
and what else about this trustee was interesting that we found out about her requirements that she's supposed to have?
yeah, she was unlicensed for 2 years. So private professional fiduciaries must be licensed by the state of California. If you're just an individual, if you were a trustee of one or two trusts, that's fine. You don't have to be licensed. But if you do this for a living and you're not a trust company, you have to be licensed. Well, she was unlicensed for 2 years, from 2008 until 2010. But she still operated as trustee, and she still took trustees' fees without prior court order during that time. Well, that's going to anger a judge. I guarantee you that if you are violating the law so blatantly like that, you're going to get clobbered. I mean, that's a bad one.
I remember the trial judge pointing out that you didn't inform the court of this.
Right.
You should have informed the court that you were continuing to take fees under this special needs trust, and you were not licensed for 2 years, something like that.
Yeah, well, I mean, number one, you shouldn't be operating as a trustee. And number two, if you are doing it and you took fees, you darn well better tell the court when you file, because that's a problem. And it's kind of like, and you say this a lot, just in terms of any trial that you're going into, is you want to tattle on yourself first. Because if you don't tattle on yourself about bad facts in your case, somebody else is going to tattle on you, and it's going to be far worse than if you just let the cat out of the bag yourself, right?
That's right. And just a brief comment on that. When I was a young attorney, and I still am a young attorney, but when I was a much younger attorney, I was in a courtroom, and I didn't hide some facts from the court, but I didn't go out of my way to try to tell those facts to the court because they were very much against my client. And I remember this old savvy attorney on the other side said, Your Honor, after I made my argument, said, Your Honor, I'm going to tell you the things that Mr. Albertson didn't tell you about. And then he kept saying that for every fact. So he said it about 10 times. And let me tell you another fact that Mr. Albertson didn't tell you about. And I learned very quick that it's probably a good idea for us not to say, and this is a little tip for younger trial attorneys out there, don't say, Your Honor, the defense is going to argue, or Your Honor, they're going to argue. Say, Your Honor, before, or the jury, madam, ladies and gentlemen of the jury, before we came here to have you look at this case, we had to determine for ourselves if there was any issues that we should be concerned about. And we want to, in full disclosure, we want to tell you those things that we need to make sure you understand that we know before we came here today, because we believe we can explain all this. And then you go through those 10 items. And I'll tell you, I did this in a jury trial once, and out of the corner of my eye, the defense attorney just kept sinking lower and lower and lower in his seat, and he kept crossing things off on his pad because I was taking away all of his ammunition.
Right.
Because once you tell on yourself, when you get up there in front and when the opposing side gets up to go, they can't say, well, what Mr. Albertson didn't tell you about, what he hid from you, what he was nefarious about. And so what you're getting at is, if this fiduciary had had her license suspended, the appropriate thing to have done would have been to go to the court of jurisdiction and immediately disclose that and say, court, what should I do?
Yeah, and certainly when you do your filing, so when she filed the petition to have her accounting approved and her fees approved, I think you have to disclose that in that filing. Tell the court, look, I want you to know we weren't licensed for 2 years. And I also would tell, if I were representing her, I'd say you're going to have to reduce your fees, because you're going to have to show the court that not only was I not licensed, but I'm doing something to make it right for the trust.
Right.
By not being licensed.
Right.
So if you go in and you don't disclose it and you want fees for those 2 years, yeah, no court's going to be happy with you. But if you go in and you say, yes, I wasn't licensed and I'm reducing my fee because of that, now you've told on yourself and you've made it right. And I guarantee you that most judges are not going to punish you if you tell on yourself and you make it right. But if you hide it and you don't make it right, yeah, you're going to get clobbered.
So this trustee also did something interesting towards the end, and maybe I'm jumping ahead here so we can back up after this, but she made some kind of a distribution or something towards the end of the trust administration without court order.
Yeah, because once the beneficiary objected, there was a little over $15,000 left in the trust. And so the thought was, well, let's just distribute this out, because the mom of the disabled beneficiary said, well, we need money to buy a house. And the trustee was talking to the beneficiary's attorney and saying, well, we both agree that if we just keep $15,000 in trust, it's going to be wasted through fees and such. So I'm just going to distribute it out to the mom so she could buy a house. The problem is the mom wasn't told that this money is so that you could put a down payment on the house for the beneficiary. And the trustee didn't follow up to make sure that that's in fact what happened.
In fact, what happened?
So mom put it in her own personal bank account and used most of it to pay her bills, the mom's bills. Well, the problem is that, and this is why I know that the beneficiary is a minor now that I think about it, is because the court specifically said, look, the mom has a legal obligation of support of the child under the family code, which means she can't use the beneficiary's money to pay for expenses that the mom is legally required to pay for, like utilities and food, groceries and all that sort of thing. And so that's what the money was used for. It was used for all of mom's bills, and the trust was not set up to benefit mom. It was set up to benefit the disabled child, and the court said that's just an improper distribution. You just couldn't do that.
Okay, so let's get back to the burdens of proof. And so just basically for the audience that aren't lawyers, this is the burden that is put on a party, and they are the ones that have to carry that burden in order to win on the claim that they're asking the court to win on. And that is quite confusing in these accounting cases. So where do we start with the burden of proof in these cases?
It is confusing. It's confusing for clients. It's confusing for lawyers. It's confusing for judges. And if you're a lawyer heading into an accounting trial, it's your number one job to educate the judge as to what the burdens are. Don't assume that the judge is readily familiar with these things, especially in a lot of our cases, they're what they call long cause trials, which means you don't get the probate judge hearing them. They get kicked out to a civil department. You might be in front of a judge who's never heard a trust case, never heard an accounting case before.
And let me just add there, because I know you feel the same way I do. These are very bright judges. We're not suggesting they're not. They just have not had a lot of exposure to these types of cases. And by the way, I would say that even probate attorneys that practice in this area are not entirely clear on what the burdens of proof are. And I think that's why this case is so great. And it just came out in August of this year. So I'm sorry for interrupting, but go ahead. I want to make sure we're clear that we're not trying to disparage anybody here. We're pointing out that this is a difficult concept to get, and this is the case you want to read before you go into your next accounting litigation matter, so that you know where the burdens of proof fall.
Yeah, and I would agree with that. I mean, it's not that the judges aren't aren't smart people. They're very bright people. And in our experience, the judges want this type of education. I mean, they want you to help them out and show them the burden. They may already know the burden, but it's still good to reinforce it. The other thing I will say to both clients and young attorneys is all this burden stuff gets real confusing during trial because it's not clear as to what's happening and when it's happening. But legally speaking, this is the burden. So when you have an accounting, first let's talk about what the trustee's burden is. So the trustee has come to court and they filed a petition asking the court to please approve this accounting. And what that means is they want the court to issue an order saying everything that the trustee did that's reported in the accounting was proper.
And so to bring that to this case, this trustee said the $15,000 distribution at the end to the mom, that's proper. The money for things that weren't necessarily proper, that's proper. So the trustee in this case is saying, I did all these proper things, and they're putting it in line item form, right?
Right.
Okay.
And they want the court to say, yes, you did everything correctly. And the other thing this trustee did in this case, by the way, is pay for a whole bunch of vacations to Hawaii and England and
Jamaica,
Florida.
I think.
Yeah, Jamaica, right.
Yeah.
They did go to Hawaii, though, too.
But they had family in Jamaica, so that's why it made sense.
Well, that's what they said.
Okay.
So they want the court to say, yes, all those line items are proper, and I'm approving it. Once it's approved, then nobody can come back and try to sue the trustee later because you have a court order approving it.
But that's an important point, though, that you just had there, Keith, and that is once a court rules basically on anything in the universe, assuming you don't appeal that ruling, which is a very short time frame to appeal a ruling, isn't that the gold standard that trustees want? If they get a court to say your trust accounting is valid and hereby approved, can anyone come back and sue them? Assuming no appeal is taken, can anyone ever come back and sue them on that accounting?
No, it closes the door. It is the gold standard. I mean, that's the best that you're ever going to do. It's even better than a release because arguably you could set aside a release if it was obtained under improper circumstances. So yeah, getting a court to approve an accounting is very important for a trustee because it closes off their liability
Right.
in the future. So here's their burden. So a trustee comes into court, I want you to approve it. The trustee bears the burden of establishing the correctness of the accounting, that the disbursements were correct in amount and the disbursements claimed were for proper purposes. So think about that. You have to show that the disbursements are correct in the amount, which means it's not good enough that you put down, I spent $2,000 on real property taxes for the trust real property. You're going to have to substantiate that in some way if the beneficiary objects to it. So here's the real property tax bill. Here's the check that I used to pay it. You can see it's cleared the bank because it's stamped on the back. There's my proof that that was the correct amount.
Okay, I have a question for you here because you said something interesting. You said if a beneficiary objects to a particular line item, if a beneficiary objects to the $15,000 payment that has gone out inappropriately, we believe that's an inappropriate expenditure, but we already know that because the court ruled. But let's assume we're not there in the case yet. We see this $15,000. We object to it. That's all we do is object to it. And the trustee says, well, Your Honor, since the beneficiary objected to that line item, they have to prove that something is wrong with that line item. Is that how that works?
No. So the trustee has to prove correctness of amount and that it was for a proper purpose. So first of all, show me that this was an actual, whatever you have listed in your accounting was a true amount and a correct amount. And then the second part of that is, was it for a proper purpose of the trust? So then you look at the trust, what were the proper trust distribution? What does the trust distribution requirements hold? And if that $15,000 was paid for a proper purpose. So in my example, when I said I paid $2,000 for real property taxes for a home, let's say, that the trust owns, I can show the receipt. So you have to show a receipt to prove that, yes, I was, the trust was asked to pay this by the county, $2,000. Here's the check, I paid it. And you can see on the real property tax bill that it's for this house that the trust owns. So therefore it was paid for a proper purpose in order to maintain property that the trust owns.
So to be clear then, the only person at this point in time in our story up to here that has a burden of proof is the trustee. And even though the beneficiary objected to that line item, the trustee's still going to have to meet this burden of proof that you've enunciated.
That's right. So yeah, it's all trustee up to this point.
Okay.
Beneficiaries, all they have to do is sit back and throw rocks,
And it seems
take
like
pot shots.
It seems like in some of the cases we've had, it does seem that the attorneys we've gone against have told us that once you object, you carry the burden to invalidate any line item. And I think this case clears up for us that it is the trustee initially now that has the burden to prove the particular line items up in each line item in the trust accounting to show that it's a proper amount and that the trust allowed it.
Yeah, and that's what's so great about this case. And these are standards that have been around for years and years. I mean, the appellate court is quoting a case from 1944, Neal versus Barnard.
Also Purdy versus Johnson.
Purdy versus Johnson is the seminal case. These cases have been around for a long, long time. But the nice thing about this case, Scott versus McDonald, is that it puts it all together, and it makes it really nice and easy to go through what the burdens are. So only the trustee has a burden to prove that the line items are proper and correct in amount and for a proper purpose. Beneficiaries don't have to prove anything. All they have to do is say, I don't like that one, and that one, and the trustee has to prove it up. The court can do it too. The court on its own motion or on its own prerogative can say, well, what was this amount and why did you spend it and was it proper? And so the problem that the trustee got into in the Scott versus McDonald case is that she wasn't able to meet the burden, right? So on the one hand, she might have been able to show that, yes, the $15,000 was actually paid and it's the right amount because I got a check to back it up. But it didn't meet the purposes of the trust because it was distributed to the mom, not the beneficiary. And it was distributed for a purpose that didn't benefit the beneficiary. And the trust required that all distributions be made out in a way that benefits the beneficiary and her life and care and comfort, not the mom's. And so it didn't meet the purpose of the trust. And for that reason, the court would deny that line item and say, I'm not going to approve that. And so I'm just not going to approve it.
Okay.
So now we're going to get to the next step, which is the surcharge. So this is where we want the court to take a step further. So we don't just want the court to deny that line item, but now we want the court to ask the trustee or order the trustee to pay that money back to the trust. That's a surcharge.
And when you say we, you're talking about the beneficiary.
Yeah, right, the beneficiary. Yeah, we always represent beneficiaries, so I think of that as we. But
Right.
the beneficiary wants the trustee to be ordered to, okay, now pay it back. And the standard for there is different because now the burden is on the beneficiary. The beneficiary, now a burden arises for them if the beneficiary wants the trustee to pay money back. And that's because it's an affirmative claim. The beneficiary wants the court to take an action against the trustee and pay something back. So this is what the beneficiary's burden then becomes, is first the beneficiary must prove that there is in fact a fiduciary duty.
Okay.
So you can't get a surcharge from somebody who didn't have a fiduciary duty over the money to begin with. Well, that's going to be easy on trust because you have a trust document, you have somebody's named as trustee, somebody's actually acting as trustee, boom, you've proven that they have a fiduciary duty. Next, you have to prove that they breached some duty that they had. So what did they breach? And then you have to show what the claim damage was from that breach. So going back to this case, Scott versus McDonald, that's where you would say, well, clearly the trustee has a duty because she's been acting as trustee. That's a fiduciary duty. What she breached is she breached her duty to follow the trust terms and make distributions according to those trust terms. That's Probate Code Section 16001. It's the number one basic duty of any trustee. You must follow the trust terms. So that was the breach. And number three, the damage was $15,000. $15,000 went out of the trust. It shouldn't have, but it did. That's where it's at. The trustee still could come back after the beneficiary has met that burden. The trustee can come back and try to prove that the 15 was in fact for a proper trust purpose, but obviously that'd be hard to do because it wasn't. That was the breach.
Okay. So let's follow that through. So far, I think you've talked about 3 burdens of proof thus far, and the first is on the trustee. When they file their accounting, they have the burden to prove up the line item and that the trust allowed that expenditure. Then you've got a beneficiary's burden of proof if they want a surcharge. In other words, they want the trustee to be personally reaching into their own pocket and paying back damages to the trust that they caused. And there they have to show that there was a duty, that duty was breached, and that there are damages. And then you say that there's kind of they don't call it a rebuttable burden of proof, but the trustee is allowed at that point in time to also have a burden to show that the expenditure that the beneficiary wants a surcharge on, that it was an appropriate expenditure.
Yeah, so the trustee can come back and rebut the surcharge by saying it was appropriate. But at that point, had it been appropriate, I don't think you would get that far.
Right.
I don't think the beneficiary would meet the beneficiary's burden
Right.
if, in fact, it was a proper surcharge. So that's what happened in this case, is that there was a meeting of that burden, and the court said, okay, well, based on that, I am going to issue a surcharge to the trustee, and I'm going to order her to pay back to the trust $93,000. And that's one hell of a surcharge. I mean, that's tough.
So the attorney that won this appeal, and it's not as hard to win appeals when you've won in the court below, right? I mean, 90% or so of cases that are won below, if they're appealed, your chances are you're going to win up. But still, it takes hard work. And I don't want to take anything away, but it's Doretha Miller, and we also know Doretha from Riverside. Very, very good attorney.
Yes.
Saw her in probate court many, many times. She's a very kind person. She fights
Yes.
hard for her clients, and what a result she got here in this case, because I haven't seen this happen in a long time.
I don't think I've ever seen this happen. I mean, trying to get that big of a surcharge against the trustee, I mean, I think given these facts, the trustee deserved it. And, but to be able to actually follow through and get it, it's not easy. It's
Right.
not an easy thing to do. We have been successful on these cases, but it's not without a lot of work and stuff going into the case. And yeah, my hat's off to Doretha Miller. She is an excellent attorney. I've worked with her and against her on cases before, and she's not to be underestimated. She's excellent, and she got a great result here for this client. And you could tell in terms of the objections she brought, and that's the other thing I'm going to tell you about beneficiary objections. She really went for the big stuff. She focused on what mattered. And you could tell that she had a passion for this case. There was something about this case that clearly, struck her sideways, and she didn't like what was happening here and what was happening to this minor disabled beneficiary, and rightly so. But in the objections that the appellate court cites, they really are focusing on the big stuff. And that's an important point for all beneficiaries, is don't sweat the small stuff.
Well, and we see even young attorneys that are first starting out in this area, when they bring in a petition like this, and they're in Miss Miller's position, where they're the ones that are objecting to the accounting, they want to object to every single line item. And I think there's some great wisdom in what you just said there. Look, you're going to confuse the court, perhaps. You're going to confuse yourself when you're trying to make your case. Pick the best ones to go after, and don't let go. Push in on those, but don't worry about the $10 that went to Walmart that probably shouldn't have gone to Walmart, because it's too much time and effort. It adds too much complexity, too much information to the case. And what we call these are a shotgun approach. We don't want a shotgun approach. We don't want to have a whole host of bullets and pellets flying out there. Nobody knows what direction they're going. We want to have very tight legal arguments based on fact that we can prove up to the court, and we want to walk the court through that one step at a time. And I wasn't there for this, but it looks like Doretha did that in this case by simply sticking to those larger items like you're pointing out, and then the court glommed onto those and said, hey, this is inappropriate. This shouldn't have happened.
You can also use categories. So one of the things I think that was effectively used here is being able to say, let's look at the category of vacations. And, all this stuff was under the category of vacations, and it came out to something like $17,000. Or the $15,000 distribution at the end, or whatever. There's ways to categorize these things and streamline the presentation for the court. But yeah, if you're going to focus on every little nickel and dime that you think is wrong here, you're just going to confuse the situation. You're going to confuse the judge, and if you confuse the judge, they're going to throw their hands up in the air and say, forget it. So I think you do have to streamline the process as much as you can, and I think this case, they did that very effectively by focusing on vacations, the end distribution, and the vehicle. Those were the big items. Oh, and the trustee's fees, because the trustee had paid herself without court order for many years. So 4 big categories.
One thing that hit me, I think this trust had a little over $200,000 in it to begin with.
Yeah.
And $34,000 in trustees' fees. That's a large amount for such a small trust.
Yeah, it is. I mean, I guess they probably would say it was for many years of service, but at the end of the day, it wasn't very. I mean, she got nothing because she had to pay back $93,000. So whatever it is she paid herself, it definitely wasn't worth it.
Right.
Because of not following the trust terms. And it's so frustrating to see a trustee get away with doing these type of acts that this trustee did. And I have to admit, it's a little satisfying to see a trustee have to pay something back for doing wrong. You know, it's the way it should be, but not always, it doesn't always work out that way. So the last thing that I want to mention that Scott and versus McDonald brought up is the difference in discretionary standards. So this trust was a discretionary trust, and it allowed the trustee to make distributions at her discretion. And there's two different probate codes on this. There's 16080, and then which is just discretionary standard, and then there's 16081, which is what we call absolute discretion or sole discretion. And the court kind of makes, I think the trustee was trying to make an issue of this on appeal. The appellate court kind of brushes it aside and says, well, this trust wasn't dealing with absolute discretion, it was dealing with just regular old discretion. And the distinction between those two is kind of interesting because with regular discretion, if a trustee is required to make distributions at his or her discretion, it's a reasonableness standard, right? So you have to make discretions in a reasonable manner, which is what we would expect. I mean, every other act of a trustee is supposed to be based on reasonableness, right? I mean, even prudent investing is what a reasonable, prudent investor would do under similar circumstances. So reasonableness is usually the standard that we're thinking of what trustees should do. Absolute discretion allows the fiduciary, the trustee, to have a little bit more control. So now they can only be in trouble if they act in bad faith or in disregard of the purposes of the trust. And that's interesting to me because when we were doing our live show last time, you brought up something about how bad faith can be a trustee ignoring the terms of the trust.
Right. And I think that's important because you might think that if this case comes along and there's absolute discretion given to the trustee that you're dead in the water. And
as a beneficiary.
As a beneficiary, that's correct. Thank you for clarifying that. But you may not be because if they simply disregarded the trust and the fact that this particular trustee said that she didn't even read the trust document. Okay, so that and like you said, the duty is to follow the trust terms. How do you follow the trust terms if you, the trustee, by the way, this is a professional trustee, you didn't even read the trust document. So how could you follow the terms? So if that's not bad faith, I don't know what is.
Yeah, it better be. And the court actually says the trustee, even with absolute discretion, the trustee is still required to avoid arbitrary action and to use her best judgment. Well, that makes sense. I mean, arbitrary action would be the trustee just doing whatever the heck they feel like it without regard to the trust terms. It also says it does not authorize a trustee to neglect the trust or abdicate her judgment. Well, that's exactly what she's doing by not following the trust terms, is just ignoring the trust terms.
Right.
And again, that goes back to Trustee Duties 101, which is you have got to follow the trust terms. So in this case, the trust didn't allow for absolute discretion, so the argument was kind of an empty argument for them to make. I think what they were trying to say is that absolute discretion would mean that you could only surcharge the trustee if she acted in bad faith. And the court said, no, well, number one, this trust wasn't absolute discretion, and number two, ignoring the trust terms is acting in bad faith anyway. So what's the difference?
I kind of picked up from this court that, and after reading this opinion, that it wasn't entirely happy with this appeal. It was almost asking it, the question, why was this appeal brought? We're not clear on the arguments that were in it. They weren't enunciated clearly. And they even painstakingly go through and say how two arguments appear to be brought on top of each other when they should have been separated out. So it appears that this appellate court was not impressed with this appeal in any manner.
And the problem with appeals, I mean, obviously, I think when you get a trustee who's surcharged to the tune of $93,000, you're going to appeal because you might as well. I mean, what do you got to lose? You might as well try. What people don't understand, though, is that the appellate court's power to set aside a trial court decision is very limited. And so I think a lot of people think, well, we'll appeal it, and the appellate court will have a chance to do the trial all over again and make a new decision. And is that how it works?
No, and the trial court is given deference. In fact, the appellate courts will actually try, and they're actually told to do this by statute, by California law. They will try to find ways to affirm the trial court's decision. In other words, they'll look at the trial court's decision, and if the trial court here surcharged $93,000, the appellate court will actually look through the record that's brought before them and try to find ways to support that $93,000 order by the court below. And I think I talked about this earlier in our broadcast here, and that is that 90% of appeals are going to be lost. When people appeal, we call that the appellate court will affirm the trial court, meaning they will agree with the trial court and disagree with the person who's bringing the appeal. 90% of the time that happens in California. That's just the way it is. And you brought up something else new, and that is, does the Court of Appeal hold another trial? Do they have a whole new look at all of this? And on questions of fact, they certainly don't. They don't do that. But there is a small exception on appeal, and that is where questions of law or interpretation of contracts is looked at, which is a question of law. And here, if there's a trust provision that needs to be interpreted, say that Judge Karaman had not interpreted a trust provision correctly, which that's not the case, but if that were the case, the Court of Appeal could look at that anew, they call that a de novo review, and determine if, in fact, a bad decision was made because there was an improper interpretation of the trust given.
Yeah, we call that de novo review, and that's not what the court used here, and it's not what the court was allowed to use here. And so what that leaves you with is either abuse of discretion or substantial evidence. Those are the only two appellate standards that the court could apply in this case. Abuse of discretion is a question of, did the trial court abuse their discretion in making their ruling? Well, there's a lot of reasons why the appellate court was not willing to say that. And so the appellate court said, no, the trial court did fine. Substantial evidence is just whether or not the trial court decision lacked substantial evidence to support the ultimate finding. And again, the court said, no, there was plenty of evidence. And like you said, there's a presumption that the appellate court is going to rule in favor of the trial court. And, and they kind of have to do that, because if they didn't, then they would end up being a second trial court. You'd end up having two trials for every case, and that's
Right.
just not the way our system works.
Right.
So that, I think, was the problem with this appeal too, is that if you're going to do an appeal, number one, it really pays to hire an appellate specialist. We're not appellate specialists, but there are appellate specialists out there. We have done some appeals, but we've also worked with attorneys who are appellate specialists, and they're excellent. And one of the things that the expertise that they can bring to the table more than anything is using the right standard. And that's so important, because you're never going to win your appeal or even have a chance of winning your appeal if you don't stack your argument in favor of the standard that the appellate court is going to use. And so that's, I think, that's what went wrong with this appeal in part, is that they probably didn't argue to the standard. And that was some of the confusion. But even if you do argue to the standard in a case like this, your chances of winning on appeal for the trustee to overturn the trial court are very, very small, because there's so much discretion in the trial court to make these decisions. So anyway, that's something about the accounting and the accounting area and the accounting burdens. It is confusing. If anybody has any other questions about it, always feel free to drop us an email, keith@aldavlaw.com or stuart@aldavlaw.com. Oddly enough, we enjoy talking about this stuff, and we talk about it a lot. And we'll talk about it again and again, and we'll talk you to sleep. We'll talk so much about it, we'll talk you to sleep. You won't need sleeping pills anymore if you just talk to us. So that's it. What else? Any other final thoughts, Stuart?
No, my only final thought would be, please join us here once a week on Wednesdays at 1:30 Pacific time. Join us. We'll answer any questions you have to the best of our ability, and we really do enjoy this stuff. And I think Keith is right. If you do have a bout of insomnia, just throw us on, and within about 3 or 4 minutes, you'll be fast asleep.
Yeah, we don't know. You feel free to ask us your questions. We are going to make this consistent, Wednesday, 1:30 p.m. We don't know everything. We just think we do. So give us a shot.
You got to say it confidently.
We think we do.
We'll see you next week.
All right.